Good afternoon. Good afternoon.
Good afternoon. Good afternoon.
How's everyone?
Pretty well.
Yeah, that's good.
Fine.
No one is watching The King. I don't understand you people.
I was watching it earlier.
Oh, okay. Is he being crowned as yet? Because I don't know.
Not sure. I'm not sure because that was a long time I was watching it. I stopped.
Oh, everybody stop. I can't
That's
get
too long for me.
Well, this is the first time it happened in 70 years. Come
Yeah.
on. It gotta be long. We're seeing a lot of things in our lifetime, so
Yeah,
have to appreciate it as it comes.
exactly.
Okay, hold on 1 second. What I did with my sheet of, oh, over there. All right. So we have some presentations to do, but before we begin presentation, let's do a recap of Unit 1, so we make sure everybody's on the same page and they understand what a company is. Donnella, you top on the list. Let's start with you.
Okay.
You don't have much. We're gonna go around until we get it.
Okay. Do I have to read the whole thing?
No, you're not reading, you're going from memory, whatever you remember.
Okay, so in the case of let's go again. Jones versus Lipman. Lipman, he had a piece of land, or he was supposed to sell some land to Jones, but he changed his mind in order to get out the obligation. So he sold it to the company that had been established for no reason. The sale was made for 3,000 pounds. And the price of the land was for 5,250. And I think he had a loan for like, I think he had like 1,000. Oh, the sale was financed by a bank loan for 1,564 pounds, which is obtained by the company, while the rest of the purchase price remained owing to Mr. Lipman. So Mr. Jones brought the action for specific performance against Lipman and the company. And Lipman then claimed that he no longer owned the land and he could not comply with the contract. So the court then made the order against both Lipman and the company, and Lipman's strategy failed. So the court then ruled in Jones' favor because Lipman was trying to get out of his obligation.
Mm-hmm.
So yeah, they had to lift the corporate rail because Lipman was trying to get out of his obligation.
Mm-hmm.
to
And the
do-
court said the company was just a sham,
it was just a sham.
just a sham.
Yeah.
Okay. But that in that case, notice that was different from the ruling that was done in Solomon.
Solomon.
Because remember now, Solomon versus Solomon established the principle that a company is a separate and legal entity all by itself.
Yeah.
What's the difference between the principle established in Solomon versus Jones versus Lipman?
Yeah.
What's the difference? Why is there a difference between the two? What was the difference?
The difference was Solomon was he was a shareholder,
Mm-hmm.
and the company was just formed, right?
Mm-hmm.
And what else?
You have to know the principles in Solomon versus Solomon and the facts of that case carry you through everything to do with company law. That's your bedrock.
Okay.
So you have to know it. You have to know why the court decided that Solomon versus his company that he formed was a separate legal entity.
Yeah.
You have to understand that principle because that goes forward and all the other types of companies that can be incorporated. Because that principle runs with that. When you say that word company, what does that mean? And Solomon versus Solomon established that principle. So go back in your notes to Solomon versus Solomon and see what is that distinction between that and the Lipman case.
Okay. Let's see. Let's see. One second, I'm trying to find. Okay. Mr. Solomon appeal the court decision in lower court is both agreed that the company was only an agent and that the formation of a company, the issue of the debenture was a scheme to enable Solomon to carry on the business. In the name of the company, the limited liability enabled them to obtain priority over the creditors by means of the debenture. Let me see. That the company had been duly formed and registered, was not a mere agent of the trustee from Solomon. Lord noted that when the memorandum is duly signed and registered corporate body, it is formed and cannot lose that status by issue the bulk of the shares to the person he stated. However, that company and law different person altogether. It's not beyond it. Okay, I'm trying. The company is not per se the agent of the shareholders with full control, concentrated only as shareholder. The mere fact that one person owns all the shares in the company does not make the business carry on that the company business. Once the company legally incorporated, the company is treated like the other independent person. I'm lost. I lost. I tried to find this thing.
All right, so in the Solomon case, how he had it structured about it. He had a sole proprietorship.
Yeah.
Then he decided to form a company. Now, to form a company, he had to file his memorandum of association.
Yeah.
So as being the subscribers, it would have been himself and his wife, his daughter, and 4 of his sons. And each of them subscribed to 1 share.
Okay.
Then they appointed Mr. Solomon and the 2 sons as directors. So now remember, he had a sole proprietorship and he's forming a company. So the company needs assets now.
Mm-hmm.
So the company paid him 39,000 pounds for his business. Because in order for the company to have assets, it had to acquire it. So
Yeah.
you could do it 2 ways. You could go out and buy the assets and put it in the business. But because he was a sole proprietor, he sold it to the company. And he was paid by the company giving him 10,000 pounds in debentures. And that was secured by a floating charge over the company's assets. So as the company would have acquired more assets, then his amount would increase.
Okay.
So, and he got 20,000 shares of £1 each, and then he got the balance in cash. But then we know the company fell on hard times and went into liquidation.
Yeah.
So if Solomon debenture was invalid, then he was a secured creditor. Because don't forget now, a debenture is a loan. So that means that the company owes him money. And he is entitled to be paid before the unsecured trade creditors. So based on the assets that were in the company, when it went into liquidation, they were enough to pay Mr. Solomon. But if the company paid him, the unsecured creditors could not get paid.
Yeah.
That's why they took him to court.
Yeah.
And so they were saying that Mr. Solomon shouldn't get paid because he was an agent of the company.
Company.
And the court said that he was not an agent of the company because he did not set out to defraud or misrepresent anybody. By him following the steps of incorporation, and he did what he was supposed to do, he didn't hide anything. Everything was clearly set out. All arrangements would be made to pay him. And that's when the court established for the first time that once you follow the steps of incorporation and you receive that certificate of incorporation, that company is a separate legal entity. But in Jones versus Lipman, he set out to defraud. His intentions were different.
Yeah. Yeah, that's true.
And that's when you see the court will pierce the corporate veil. It's when you set out to defraud.
Defraud.
All right.
I get it now.
You get it now?
Yeah.
Okay. But you will see in other cases that nowadays the court is trying not to pierce the corporate veil, because they say that if the court continues to pierce the corporate veil, then what is this whole concept of having a company that provides protection?
Yeah, that's true.
And that's why you see in the case of Pest versus Petrodel that we'll go through, you'll see why the court decided that they were not piercing any veil. Because he didn't set out to hide anything from her. That is just how he structured his assets. So make sure you grasp that concept of Solomon versus Solomon, because that everything going forward has to do with what's a company. And that's why places are forming companies for that same protection. All right, so your presentation wasn't bad. Very good. Thank you very much.
You're welcome.
Okay, who's next? Who's volunteering? Everybody have their cases. Only person absent today is Krista. Who's next? Who's gonna go next? Atalia? Did you do yours? Or we could have Nadia. Nadia, can you do Guilford Motor? Atalia's coming on. Atalia or Nadia, anyone? Okay,
Nacho.
hi. You ready to present your case?
No, I need a little more time for my case.
Okay, so let's get Nadia. Nadia, you ready with yours? I didn't hear anything. Nadia. Because Guilford Motor is also a piercing of the veil. So no answer there. What's the name? Walk-in?
Yes, ma'am, I'm here.
You ready?
Somewhat.
Okay.
Okay, I'll just present what I have.
Mm-hmm.
Okay, so I had the case of Yukon Align Limited versus Rendsburg Investment Corp.
Mm-hmm.
Okay, so basically, Yukon entered a 3-year contract with Rendsburg in July of 1995. They had a vessel called Ratio that was due to charter in early 1996. Rendsburg took the form of a telex, which is how they sent messages back then.
Hey, back then.
Okay, so Rendsburg took form of a telex on January of 1996. It was sent by the broker of Yukon. Yukon accepted the telex on the 1st of February of 1996. Sorry, hold on, I lost where I was reading. For repudiation. After Rendsburg had failure to respond to the request, confirming the charter party, which was the contract that they went into agreement with. Okay, can I say it in my own words?
Yes.
Okay.
Simple as possible.
Sorry?
As simple as possible.
As simple as possible. Okay,
Mhm.
so
Go ahead.
basically, Yukon informed, Rendsburg informed Yukon that they were unable to perform the charter party due to their financial position. Uh, Therefore, Yukon issued them a writ because they had already went into contract for the vessel to charter these material.
Mhm.
Hold on. Sorry, because I had in my summary, I was piecing together different things to try to understand the full case.
Mhm. So you need more time.
Yes, ma'am.
Okay. So I'm gonna put more time next to your case. So next week you'll be able to tell me exactly what it is.
Yes, ma'am. No problem.
That's two with more time. Hold on, let me get my pen.
Ms. Archer, can you pencil me in for a little more time as well,
No.
please?
Hold on, let me get my pen first. You gotta try.
Yeah, I will try, but need a little more time.
More time, more time, more time. There's more time. Don't. Only Donella was ready.
Yeah.
Okay, I know Crystal is out. And okay, so Atali says more time. Next week for NW. Who else for NW?
Miss James, please, for more time, please.
Oh Lord, NW.
And
Who
me
else?
as well.
NW. What about Nadia?
Miss Nadia said she had to step out for a brief moment to
Oh,
pick someone up at the hospital.
oh. Okay, so who else is missing off this? Oh, she's not on today. Okay, let's leave the cases till next week. We agree?
Yes, please.
Okay,
Ma'am.
so let's all move to the case of Press versus Petrodel then. How about that? You have it, right?
Yes, ma'am.
Okay, let's go there then.
What page is that?
No, that's not a page.
What's that?
Sent it to you.
Yeah.
Now, did you have opportunity to read this one? Say
That
yes.
was-
Hi, Miss Archer. I'm not seeing where it was sent to me.
Likewise, I don't think I received that.
Let me see.
What's that sound?
Hold on. I'm trying to do fly all. Let me see what comes up. Everybody.
I didn't get it either, Ms. Acho.
Okay, hold on. I'm doing I'm trying to pull mine up. Hmm. Okay, hold on. If you didn't get it, tell me when you receive it. I sent it.
I think I just got it. Let me see.
Okay.
Yeah, I just got it.
So this was an ancillary relief, which means it was after the divorce was granted. So now they're having a discussion to divvy up the assets. So the principal parties before the judge was Moulin J. Before the judge, Moulin J. were Michael and Yasmin Press. He was Nigerian, born in Nigeria, and she was born in England. So they had dual nationality. They were married in 1993, and during the marriage, the matrimonial home was in England, although the husband was found by the judge to have been resident in Monaco from about 2001 to date. And there was also a second home in Nevis, and the wife petitioned for divorce in 2008. And the decree nisi was pronounced in 2008 December, and then they got the absolute in 2011. So even though the husband is not a party to this appeal, because the notice it says Press versus Petrodel Resources Limited and others, he is not a party to this. The appeal concerned only the position of a number of companies belonging to the group known as the Petrodel Group, which the judge found to be wholly owned and controlled directly or through intermediate entities by the husband. So everybody understand what that picture looks like?
Is this from the previous case or is this a new case? Good afternoon.
What do you mean previous case?
Because I catch the tail end, you were talking about some ancillary matters.
No, this is the case of Press versus Petrodel.
From unit 1?
Yeah, from Unit 1.
Oh, okay,
Yeah, which I just sent in the email.
thank you.
Yeah, okay. So in your mind or on a piece of paper, if you have a piece of paper next to you, you have husband and wife. So you could do 2 sticks, man and woman. So he has and she has dual nationality. But his domicile of choice is Monaco. So they have at the very top, they have what they call the Petrodel Group. And underneath this group, and see where it says in paragraph 2 that it was owned directly or through intermediate entities. That means that he has holding companies within the structure. So they were Petrodel Resources Limited. There was Petrodel Resources Nigeria Limited, Petrodel Upstream Limited, Vermont Petroleum Limited, Elysium DM Limited, Petrodel Resources Nevis Limited, and Elysium DM Nevis. All of these companies he had. 3 of these companies, PRL, Upstream, and Vermont, were incorporated in the Isle of Man. PRL was the owner of the matrimonial home, which was bought in the name of the company in 2001. So he purchased the matrimonial home in the name of his company, PRL. There is no longer any issue about that property, which is apparently in the process of being transferred to the wife. So in addition, PRL was the legal owner of 5 properties in the UK, and Vermont is the legal owner of 2 more. The question on this appeal is whether the court has power to order the transfer of these 7 properties to the wife, given that they legally belong not to him, but to his companies. Now you see what the issue is? At the very top of the structure is the husband. And under him, he has companies, and companies are holding assets. So under paragraph 3, it says section 23 of the matrimonial clauses provides for periodical and lump sum payments to a spouse or for the benefit of children of the marriage. And it says the court may order that a party to the marriage should transfer to the other party such property as may be so specified, being property to which the first mentioned party is entitled, either in possession or in reversion. So what the wife was looking for is to receive these 7 properties. And they went before the court to see if the court was going to pierce the corporate veil and give her these 7 properties. So if we move now to paragraph 10, that's page 6. It says most of the judge's findings of fact were directed to 2 questions which are no longer in dispute, namely whether the husband owned the Petrodel Group and what was the value of his assets. For present purposes, it is enough to summarize those which bear on the position of the 3 corporate respondents. At the time of the marriage and throughout the 1990s, the husband was employed by a succession of major international oil trading companies as a trader. In 2001, he left his last employer, Mark Rich, and began to run his own companies. Initially, there were 2 principal companies involved, Aurora and the Petrodel companies. In 2004, Aurora was wound up, and thereafter, he operated mainly through the Petrodel companies. The principal operating company of this group was PRL, a company incorporated in the Isle of Man. Its statements record that it was incorporated on the 4th of May, 1993. It was dormant until 1996 and did not begin operations until the 25th of April, 2002. That is after the husband had left Mark Rich and set up on his own. Between 1996 and 2002, it is described in his financial statements as a property investment company. Its sole function in that period appears to have been to hold title to the matrimonial home in London and 5 residential investment properties in London, and to act as a channel for funding property purchase by other companies of the group. The husband's evidence was that the company had engaged in substantial agricultural and oil-related business in the 1990s, in part in association with his then employer, Mark Rich. But this was inconsistent with the company's financial statements, and the judge rejected it. Mr. Lee Breton, a former business colleague of the husband, gave evidence at the hearing, which a judge accepted as reliable. Mr. LeBrenton said that from about 2001, PRL was engaged in a limited way in oil drilling and shipping, and from 2006, moved into oil exploration and production in Nigeria and West Africa. The latest disclosed accounts of PRL are draft accounts for 2008 and 2009. And the judge declined to attach any significant weight to the financial data. Paragraph 12, management control of PRL has always been in the hands of the husband, ostensibly as chief executive under a contract of employment conferring on him complete discretion in the management of its business. Remember when we did last week when we just did the synopsis of the case of Lee Farming? Remember in Lee Farming, even though he owned the company, he had a contract with the company to do the spraying for the share crop. Similar in this one, the husband had a contract with the company to act as its chief executive. The judge found that none of the companies had ever had any independent directors. The husband is a director of PRL Nigeria, but otherwise the directors are all nominal or professional directors, generally his relatives, who accept directions from him. The directors of PRL are Mr. Murphy and a lady in Nevis who appears to have been the couple's cleaner there. So these are just names that he put in, but he is actually the one with all the control. So the judge said the ownership of the respondent companies proved to be more difficult to establish. The husband did not admit to having any personal interest in the shares of any company of the group and declined to say who the ultimate shareholders were. All of the issued shares of PRL were owned by PRL Nigeria. Almost all the shares of that company were owned by PRL Nevis, a company about which very little is known, but whose accounts show substantial balances arrived from trading. The husband evidence was that the shares of PRL Nevis were owned by its own subsidiary, PRL Nigeria. The judge described this as puzzling, but made no finding as to whether it was true. More recently, it has been suggested that PRL Nevis is owned by a family trust, about which, however, nothing has been disclosed. So then they accounted for what was in Vermont, and the shares were held 49% by PRL and 51% by PRL Nigeria and Upstream. So in paragraph 15, it said the husband declined to answer the question whether he received any benefits from PRL other than his salary, saying that this was an accounting question. The judge, however, made extensive findings about this. He found that his personal expenditure substantially exceeded his salary and bonuses as chief executive, and that the differences funded entirely by the company. There was no formality involved. The husband simply treated the company's cash balances and property as his own and drew on them as he saw fit. The judge found that the husband had unrestricted access to the company's assets, unconfirmed by any board control or by any scruples about the legality of his drawings. He used PRL's assets to fund his and his family's expenditures, including the substantial legal costs incurred in the present proceedings. Said the group was effectively the husband's money box, which he uses at will. So then the court then decided to go through and talk about piercing the corporate veil. He says, but when we speak of piercing the corporate veil, we are not and should not be speaking of any of these situations, but only of those cases which are true exceptions to the rule in Solomon versus Solomon. That is, where a person who owns and controls a company is said in certain circumstances to be identified with it in law by virtue of that ownership and control. He said the most advanced legal systems recognize corporate legal personality while acknowledging some limits to its logical implications. He says in paragraph 18, English law has no general doctrine of this kind, but it has a variety of specific principles which achieve the same results in some cases. And one of these principles is that the law defines the incidence of most legal relationships between persons, natural or artificial, on the fundamental assumption that their dealings are honest. So 20, he says, almost all of the modern analysis of the general principles have taken as their starting point the brief and obiter but influential statement of Lord Keith in Wolfson versus Strathclyde Regional Council. This was an appeal from Scotland in which the House of Lords declined to allow the principal shareholder of a company to recover compensation for the compulsory purchase of a property which the company occupied. The case was decided on its facts. But at page 96, Lord Keith, delivering the leading speech, observed that it is appropriate to pierce the corporate veil only where special circumstances exist, indicating that it is a mere facade concealing the true facts. The first systematic analysis of the large and disparate body of English case law was undertaken in the case of Adams versus Cape Industries PLC. The question at issue in the case was whether the United Kingdom, parent of an international mining group, which was at least arguably mentioned as a single economic unit, was present in the United States for the purpose of making a default judgment of a US court enforceable against it in England. And in that case, the court adopted Lord Keith's dictum in Wolfson versus Strathclyde. It held that the corporate veil could be disregarded only in cases where it's being used for a deliberately dishonest purpose. Apart from that, and from cases turning on the wording of particular statutes, it held that the court is not free to disregard the principle of Solomon versus Solomon, merely because it considers that justice so requires. Our law, for better or worse, recognizes the creation of subsidiary companies, which, though in one sense the creatures of their parent companies, will nevertheless, under the general law, fall to be treated as separate legal entities with all the rights and liabilities which would normally attach to separate legal entities. Then he said in the case at paragraph 22, Trustor versus Smallbone, where Sir Andrew Morritt reviewed many of the same authorities. Mr. Smallbone was the former managing director of Trustor, and he had improperly procured large amounts of its money to be paid out of its account to a company called Introcom Limited. That was incorporated in Gibraltar. Introcom was owned and controlled by a Liechtenstein Trust, of which Mr. Smallbone was a beneficiary. Its directors acted on his instructions. At an earlier stage of the litigation, Trustor had obtained summary judgment on some of its claims against Introcom, on the footing that the payments were unauthorized and a breach of Mr. Smallbone's duty as managing director, that the company was simply a vehicle for Mr. Smallbone used for receiving money from Trustor, and that his knowledge could be imputed to the company. The Vice Chancellor was dealing with a subsequent application by Trustor for summary judgment against Mr. Smallbone himself. It was accepted that there was an arguable defense to the claims against him for damages or compensation for breach of his duties as a director of trustor. Accordingly, the sole purpose of the application was that he was liable to account as a constructive trustee on a footing of knowing deceit. This depended on the proposition that he was to be identified with Intracom and so treated as having received the money himself. It was submitted that the authorities justified piercing the corporate veil in 3 possibly overlapping cases. 1, where the company was a facade or a sham. 2, where the company was involved in some form of impropriety. And 3, where it was necessary to do so in the interest of justice. In each of these cases, the right of the court to pierce the corporate veil was said to be subject, so there being no third-party interest engaged, such as unconnected minority shareholders or creditors. The Vice Chancellor concluded that the authorities supported the submission in case 1 and also in case 2, provided that the impropriety was a relevant one, that is, linked to the use of the company structure to avoid or conceal liability for that impropriety. He followed in Capes versus Adams in rejecting the submission as applied to case 3, applied to case 3. In summary, the court was entitled to pierce the corporate veil and recognize the receipt of the company as that of the individual in control of it, if the company was used as a device or facade to conceal the true facts, thereby avoiding or concealing any liability of those individuals. So in this case of Press versus Petrodel, what the court did was the court looked at some of the infamous cases where the court would have pierced the corporate veil. And what the judge is doing is giving his justification as to whether the piercing of the veil should have actually been done. And is trying to narrow down for company law judges as to when the courts will actually pierce the corporate veil. So this case is a very important case to read for you to understand. 1, that a company has a separate legal personality. 2, when the courts will pierce the corporate veil. Any questions so far? Because there are other cases that he's going to go through, but I'm not going to read those to you, because you're going to read them and you read the full case this week. So in paragraph 27, he said, in my view, the principle that the court may be justified in piercing the corporate veil if a company's separate legal personality is being abused for the purpose of some relevant wrongdoing is well established in the authorities. It is true that most of the statements of principle in the authorities are obiter. Obiter means that it's just a discussion point, because the corporate veil was not pierced. It is also true that most cases in which the corporate veil was pierced could have been decided on other grounds. But the consensus that there are circumstances in which the court may pierce the corporate veil is impressive. I would not, for my part, be willing to explain that consensus out of existence. This is because I think that the recognition of a limited power to pierce the corporate veil in carefully defined circumstances is necessary if the law is not to be disarmed in the face of abuse. So at 28, he says, the difficulty is to identify what is relevant wrongdoing. References to a facade or sham beg too many questions to provide a satisfactory answer. It seems to me that 2 distinct principles lie behind these proton terms, and that much confusion has been caused by failing to distinguish between them. They can conveniently be called the concealment principle and the evasion principle. He's referring to facade and sham. He says the concealment principle is legally banal and does not involve piercing the veil at all. It is that the interposition of a company or perhaps several companies so as to conceal the identity of the real actors will not deter the courts from identifying them, assuming that their identity is legally relevant. In these cases, the court is not disregarding the facade, but only looking behind it to discover the facts which the corporate structure is concealing. The evasion principle is different. It is that the court may disregard the corporate veil if there is a legal right against the person in control of it, which exists independently of the company's involvement. And a company is interposed so that the separate legal personality of the company will defeat the right or frustrate its enforcement. Many cases will fall into both categories, but in some circumstances, the difference between them may be critical. And this may be illustrated by reference to those cases in which the court had been thought rightfully or wrongfully to have pierced the corporate veil. And then he went to the most famous case of Guilford Motor Company versus Horn. And the whole 29 is on Guilford and 30 is on Jones versus Lipman. Then in paragraph 31, he went to the case of Gencor. And 32, he went back to Trustbore and Smallbone. And he compared Trustor, Guncor, Guilford, and Jones. So now in paragraph 36, he says, in the present case, Mullen J. held that he could not pierce the corporate veil under the general law without some relevant impropriety, and declined to find that there was any. In my view, he was right about this. The husband has acted improperly in many ways. In the first place, he misapplied the assets of his companies for his own benefit. But in doing that, he was neither concealing nor evading any legal obligation owed to his wife. Because remember, at the court below, they said that he used the funds from the companies to pay his expenses in his marriage. Nor more generally was he concealing or evading the law relating to the distributions of assets of a marriage upon its dissolution. It cannot follow that the court should disregard the legal personality of the companies with the same insolence as he did. Secondly, the husband has made use of the opacity of the Petrodils Group corporate structure to deny being its owner. But that, as the judge pointed out, it is simply the husband giving false evidence. It may engage what I have called the concealment principle, but that simply means that the court must ascertain the truth that he has concealed as it has done. The problem in the present case is that the legal interest in the properties is vested in the companies and not in the husband. They were vested in the companies long before the marriage broke up. Whatever the husband's reasons for organizing things in that way, there is no evidence that the husband reason for organizing things in that way. There's no evidence that he was seeking to avoid any obligation which is relevant in these proceedings. The judge found that his purpose was wealth protection and the avoidance of tax. It follows that the piercing of the corporate veil cannot be justified in this case by reference to any general principle of law. Anybody have any comments to that paragraph? No? So at paragraph 39, the judge's answer to that question was that the purpose and intention of the Matrimonial Causes Act was that the company's assets should be treated as part of the marital wealth. Effectively, he said the husband, in respect of the companies and their assets, is in the same position he would be in if he was the beneficiaries of a bare trust, or the companies were his nominees. And the judge then said, I do not accept this any more than the Court of Appeals did. The judge was entitled to take account of the husband's ownership and control of the companies and his unrestricted access to the company's assets in assessing what his resources were for the purposes of Section 25 of the Matrimonial Causes Act. But he was not entitled to order the company's assets to be transferred to the wife in satisfaction of the lump sum order simply by virtue of Section 24 of the Matrimonial Causes Act. So the judge says, there is nothing in the Matrimonial Causes Act and nothing in its purpose or broader social context to indicate that the legislature intended to authorize the transfer by one party to the marriage to the other of property which was not his to transfer. Because remember, the properties are owned by companies. Secondly, a transfer of this kind will ordinarily be unnecessary for the purpose of achieving a fair distribution of the assets of the marriage. Where assets belong to a company owned by one party to the marriage, the proper claims of the other can ordinarily be satisfied by directing the transfer of the shares. It is true that this will not always be possible, particularly in cases like this, where the shareholder and the company are both resident abroad in places which may not give direct effect to the orders of the English court. In an age of internationally mobile spouses and assets, this is a more significant problem than it once was, but such cases remain the exception rather than the rule. Section 24 of the Matrimonial Causes Act cannot be construed as if it were directed to that problem. So far as a party to matrimonial proceedings deliberately attempts to frustrate the exercise of the court's ancillary powers by disposing of assets, Section 37 provides for the setting aside of those dispositions in certain circumstances. So he says in 41, it is clear from the judge's findings of the fact that this particular husband made free with the company's assets as if they were his own. That was within his power, in the sense that there was no one to stop him. But as the judge observed, he never stopped to think whether he had any right to act in this way. And in law, he had none. The sole shareholder or a whole body of shareholders may approve a foolish or negligent decision in the ordinary course of business, at least where the company is solvent. Mr. Press is, of course, not the first person to ignore the separate personality of his company and pillage its assets, and he will certainly not be the last. But for the court to deploy its authority to authorize the appropriation of the company's assets to satisfy a personal liability of his shareholder to his wife, in circumstances where the company has not only not consented to that course, but vigorously opposed it, would, as it seems to me, be an even more remarkable break with principle. It may be said, as the judge in effect did say, that the way in which the affairs of this company was conducted meant that the corporate veil had no reality. This is a proposition which can be justified only by asserting that the corporate veil does not matter where the husband is in sole control of the company. but that is plainly not the law. It follows from the above analysis that the only basis on which the companies can be ordered to convey the 7 disputed properties to the wife is that they belong beneficially to the husband by virtue of the particular circumstances in which the properties came to be vested in him. Only then will they constitute property to which the husband is entitled, either in possession or in reversion. The issue requires an examination of evidence which is incomplete and in critical aspects obscure. A good deal therefore depends upon what presumptions may properly be made against the husband, given that the defective character of the material is almost entirely due to his persistent obstruction and mendacity. So you see, even though the company is a separate legal entity, even though it was structured in this way prior to the marriage, the court is saying that they cannot pierce the corporate veil because he is not trying to defraud. He was not concealing. But the thing is now to bring home the point that even though those things were not evident in the case, he was using the assets, spending the asset, the profit from the company, as if it was in his back pocket. So that meant that as the chief executive officer, he was not following the protocol of a company, meaning that he was not filing resolutions to effect the changes as he withdrew funds from the company. All he was doing was just taking the funds out and spending it, and not running the whole structure as if it was a company. Any comments so far? Everybody understand? Everybody is quiet, so that means yes. So the question now is, how will the wife obtain any assets in this divorce settlement? Saying that the courts will not pierce the corporate veil. The question now is, how will she receive benefit from the structure? Anybody have any ideas as to how? No?
They would have to go after the husband's, they'd have to go after the husband, since he's not paying himself a salary and he's spending more than he's making. They should go after him directly. That's my opinion.
But how you going behind him directly and his money comes from those assets? That's where he spends his money from.
But if he's not filing, and if he's not giving an account for it, and he's using it as his public purse, why not get it from him? Because and one of the houses were a part of the matrimonial home.
She got that one. She got the one. She got the matrimonial home. She's back now for more property.
If they're in a company, I don't see how. And it isn't like, and I think that is why he probably had those companies incorporated in separate in different countries. Probably knew that, you know, it was going to get through to find out all the information about the company is going to be probably difficult, because not all laws are the same as the English law. So therefore, trying to get information is going to be quite difficult. So and they are not proving that he owns them directly, especially if you're not filing your annual returns.
Mm-hmm. Yeah. And then, so don't forget now, you see how he has it structured? Each one of the companies in the layers incorporated in another jurisdiction. So there's there's so many different laws to go through to get what she's trying to get. So-
He probably was married before and then something similar happened to him, and when he was in one jurisdiction, that's probably why he did it in separate jurisdictions.
To protect themselves.
Yes, ma'am.
All right, so let's read on. I told you this is a very good case. So you see the judges already said that they can't pass the veil. That's a mute point. They went through all of the passing of the corporate veil in the past, the most recent ones before this case, and they said it doesn't fall in all fours. It just, no grounds are there to pass the corporate veil. So let's see what he says now. He says in 45, the modification to which I have referred concerns the drawing of adverse inferences in claims for ancillary financial relief in matrimonial proceedings, which have some important distinctive features. There is a public interest in the proper maintenance of the wife by her former husband, especially but not only where the interests of the children are engaged. Partly for that reason, the proceedings, although in form adversarial, have a substantial inquisitorial element. The family finances will commonly have been the responsibility of the husband. So that although technically a claimant, the wife is in reality dependent on the disclosure and evidence of the husband to ascertain the extent of her proper claim. The concept of the burden of proof, which has always been one of the main factors inhibiting the drawing of adverse inferences from the absence of evidence or disclosure, cannot be applied in the same way to proceedings of this kind as it is in ordinary civil litigation. These considerations are not a license to engage in pure speculation, but judges exercising family jurisdiction are entitled to draw on their experience and to take notice of the inherent probabilities when deciding what an uncommunicative husband is likely to be concealing. I refer to the husband because the husband is usually the economically dominant party. But of course, the same applies to the economically dominant spouse, whoever it is. The facts so far as the judge was able to make findings about them are that the London properties were acquired as follows. December 1995, the flat on Abbey Road was transferred to PRL by the husband for £1. It had been bought by him in 1991 before the marriage and before the incorporation of PRL. There are 2 charges on the property in favor of Hallie United Bank and BNP Paribas, apparently to secure loans made to PRL. Neither the husband nor PRL has complied with orders to disclose the loan agreement and related documents. Flat number 5 on Abbey Road was transferred to PRL on the same day, also for £1 by the husband's younger brother, Michael. It had been bought in March for £48,650 in Michelle's name. The wife's evidence was that at the time, Michelle was a student in London with no substantial assets of his own, who was being supported by her husband. She said that her husband had led her to believe that he had paid for it. March 1996, flat number 2 on Ashmore Road is the leasehold property transferred to PRL for £1 by the wife. It had originally been bought by the husband in November 1992 in the name of someone called Jimmy Lawrence. There's no information on Jimmy Lawrence or the reasons for his involvement. According to the husband's evidence, the purchase money came from PRL, but since PRL was not incorporated until 6 months after that, this cannot be correct. At some stage, it was unclear when and how the lease was transferred into the name of the wife, and she must have signed the transfer when it was conveyed to PRL, but she had no recollection of being involved or ever having owned it. In 98, the wife transferred her interest in the freehold of 143 Ashmore Street to PRL. The freehold originally being bought in 1996 in the name of the wife and one Esther Bleshman, who was the leasehold owner of another flat in the building. And there was no information about the consideration paid either in 96 or 98. The husband's evidence was that the funds to buy the wife's interest in 96 came from PRL. In August 2000, there was a flat, Beethoven Street, was transferred to PRL by the husband for £85,000. He had bought it in 1988 for £70,500. And that had also been charged to secure loans with the same two banks. May 2001, they had the matrimonial home. The value of that, it was in the name of PRL. The value of that was 1.4 million. And he refurbished it for about 1 million. The judge rejected the husband's evidence that the purchase price and refurbishment costs were funded by PRL because at that stage, the company had not commenced trading operations. He found that they were funded from bonuses earned by the husband, presumably at this stage from his last employer, before he set up on his own. The judge found that PRL had always held this property on trust for the husband, and that conclusion is not challenged on this appeal. The property is charged to secure the loans made by the bank, the two banks. In accordance with the judge's order, PRL has now conveyed it to the wife, but subject to the charges. Remember, I said at the beginning that she got the matrimonial home. Then July 2001, got some apartments. The value was £635,000. In 2004, he bought another, he bought a lodge for $700,000. So the judge recorded the wife's evidence that the husband had once advised her that if anything were to happen to him, she should sell all the properties, move to Nevis, and use the proceeds of sale to meet her living expenses. That sound true to you?
No, it does not,
Why?
because he knew just what he was doing. Because what he did was he bought, he had the wife sign documentations transferring over her rights in those properties, knowing fair well what was going to happen. Even if he did not know directly, he knew indirectly. And that's just malicious on his part.
But even more than that, he knew that it was in a company structure. She was not on the company. She was not a
No, she was
director.
not even a director or even a secretary. She didn't even own
Nothing.
any shares. So
None of those things. So him telling her that was just to keep her quiet.
yes, and to have and by him telling her that, listen, if something was to happen to me, you could sell these things. He was telling her all these things just so she could sign over her interest or her dower in the properties.
So he said the starting point is that in her points of claim, the wife expressly alleged, among other things, that the husband used the corporate defendants to hold legal title to properties that belong beneficially to him. All 7 of the properties in dispute on this appeal were identified in her pleadings as having been held for him in this way. In her Section 25 statement, she gives evidence of her belief that he was their beneficial owner, supported in some cases by admittedly inconclusive reasons for that belief. Neither the husband nor the companies have complied with orders for the production of the completion statements on the purchase of the properties and evidence of the source of the money used to pay the purchase price. The companies were joined to these proceedings only because they were alleged to be trustees for the husband of the shareholding and the properties, and because orders were being sought for their transfer to the wife. Yet the companies failed to file a defense or to comply with orders for disclosure. One of the few things that is clear from Mr. Murphy's affidavit was that the company's refusal to cooperate was deliberate. notwithstanding that they were conscious that the London properties, unlike the other properties, were within the jurisdiction of the court, which was in a position directly to enforce any order that it might make in respect of them. The only explanation proffered for their contumacy was that the information was confidential to the company's shareholders or commercial partners. It is difficult to imagine that any commercial partners could enjoy rights of confidence over information concerning residential investment properties in London. And on the judge's findings, the only shareholder was the husband himself. So he said, turning to what, paragraph 48, turning to what is known about the acquisition of the disputed properties. PRL acquired the legal interest in 6 London properties between 1995 and 2001. All of these properties were acquired by PRL before it began commercial operations and began to generate funds of its own. This was the main basis on which the judge found that the matrimonial home was held on trust for the husband from its acquisition in 2001. Since, as the judge found, no rent was paid to PRL for the family's occupation of the matrimonial home, this is a particularly clear case of the husband using PRL as a vehicle to hold legal title on trust for himself. So of the other 5 properties owned by PRL, the first category comprised the 3 properties acquired by the company in 95 to 96, in each case for a nominal consideration of £1. Since no explanation has been forthcoming for the gratuitous transfer of these properties to PRL, there is nothing to rebut the ordinary presumption of equity that PRL was not intended to acquire beneficial interest in them. The only question is, who did hold the beneficial interest? Flat 4 at 27 Abbey Road was transferred by the husband, who had originally bought it in his own name in 91, before PRL was incorporated. There is therefore an ordinary resulting trust back to the husband, which is held by him subject to the charges in favor of the 2 banks. Then the flat number 5 on Abbey Road was transferred to PRL by the husband's younger brother. He had acquired title shortly before the time when he could not have paid for it himself. The wife's evidence was that the husband paid for it. Again, there's no evidence to rebut the ordinary inference that the husband was the beneficial owner of the property at the time of the transfer to PRL, and that the company held it on a resulting trust for him. The leasehold interest in flat 2 was transferred to PRL by the wife. The rather curious chain of title before that is summarized above. The circumstances suggest that the husband must have provided the purchase money and was the beneficial owner when the legal estate was held by Jimmy Lawrence, and also at the time of the transfer from him to the wife. Either it then became the beneficial property of the wife, which is what equity would initially presume, or else it remained in the beneficial ownership of the husband, which is what I would on balance infer from the wife's evidence that the transfer was procured by the husband without her conscious involvement. Now you see where she's leaning now, right? She's saying that she did these things, she did the transfer, but she was unconscious of what was actually being done. In either case, the company, as the legal owner, can be required to transfer the property to the wife. I conclude that the husband was at all relevant times the beneficial owner of all these properties. So the judge then went through each one of the properties. So he says, I conclude that both of the properties acquired in the name of Vermont were beneficially owned by the husband. He says, the intention would normally be that the spouse in control of the company intends to retain a degree of control over the matrimonial home, which is not consistent with the company's beneficial ownership. Of course, structures can be devised, which give a different impression. Some of them will be entirely genuine, but where, say, the terms of acquisition and occupation of the matrimonial home are arranged between the husband in his personal capacity and the husband in his capacity as the sole effective agent of the company. Judges exercising family jurisdiction are entitled to be skeptical about whether the terms of occupation are really what they are said to be, or are simply a sham to conceal the reality of the husband's beneficial ownership. So conclusion, I would accordingly declare that the 7 disputed properties vested in PRL in Vermont are held on trust for the husband, and I would restore paragraph 6 of the order of Mullen J. so far as it is required those companies to transfer them to the wife. Subject to any contrary submissions to the cost, I would also restore paragraph 14 of the judge's order so far as it dealt with the cost payable to PRL and Vermont. I would order them to pay the cost of the appeal to the Court of Appeal and to this court. As at present advised, I would not require upstream against whom no relief has ever been sought to pay any costs, but in the rather unusual circumstances of this case, I would not make any cost order in their favor. And y'all could read Judge Newberger's comments. So that was the case of Press versus Petrodel, which right now is where the court rests when it comes to piercing the corporate veil. Any comments? So when you present your case next week, you should be able to see what the court did. And you can compare it to Press versus Petrodel. Any comments? No, yes?
So the husband wasn't awarded the pay cost?
Yeah, the husband, yeah, PRL, not the husband, the company. Remember now, the husband never came to the trial, you know. She was suing the companies. And they gave her the properties without
As
piercing the
they-
corporate veil.
As they should. Because he was, because most of the times when people want to hide certain things or their assets, they form companies.
Yeah, but he wasn't hiding.
He wasn't, because he was bold enough to do it openly.
Yeah, right, and she participated in it.
The fact that he was buying properties and putting it in his brother's name and then later having it transferred. So he
And
was
he
not
put-
hiding it.
No, and he put it in her name and transferred also into PRL. But then he used those assets as leverage to start his business. Remember, the assets were pledged. So he had
But-
loans against those properties.
My thing is, if he was the sole beneficial owner of those companies, right?
Mhm.
Or the sole director. And he was not filing any annual returns, holding no general meetings, nothing whatsoever, no resolutions. So who was signing those documents on his
Him.
behalf?
Him, he was the chief executive officer. He ran the companies too. He can do that, you know. He can be
Yeah.
the shareholder He can appoint himself as director. He can appoint himself as officer. He could do that. Once he put those assets within that company, the assets belong to the company and no longer to him.
But did he sign a trust though?
No. What the court is saying is that when you look at the structure, right? And the way the assets were put, his intent when he put the assets into those companies, then the company really was just holding those assets in trust for him. Because he just took the assets and leveraged the assets to get his operational business going. That's what he did. So instead of the banks having to question him that he has this bulk of money in cash and he's securing a loan with bulk of cash, he used property. Because with the property would be less question. Because all you have to do is get an appraised value on those properties. So he avoid a lot of red flags by doing that. And then that's why he also didn't put a lot of them into his own name. Again, it would have raised more flags.
And then the woman could, the wife could have gotten more out of him rather than just the 7 companies.
Yeah, she could have, but she wanted the 7 properties. That's what she asked for. She asked for those 7. So it's a good case you to sit down and read while you're watching the coronation. All right. For chapter 2, I had a brilliant idea. And tell me if you all agree. I think Miguel sent the schedule. You had a chance to look at it? Okay, so midterm is on June the 10th. And what I propose to do, and let me know if you agree. Unit 2 talks about types of companies. Now, in the Bahamas, you can incorporate a company under the Companies Act or under the International Business Companies Act. We also have other products that are not companies per se, but they're all a part of the product of structuring. So similar to TCI, TCI have, your companies are divided into domestic, international, I think you have protected sale, and then you have non-profits. So ours is structured a little bit different. We have CACs, which could be domestic. And it can also do business internationally. And then we have IBCs, which are international for international clients, but Bahamians can also incorporate IBCs. Your protected sale is the same as what we call segregated accounts. And then we do have nonprofit organizations. So this is what I'm going to propose, and you'll let me know if you agree, because I think it'll be easier. As a part of your midterm, because this falls under the chapters for midterm, I would put as a question, which I could send you all this week, so you can get this question out of the way. I could make it worth 30 points and ask you to present or write a presentation to an audience, and I'll tell you from which jurisdiction, and you describe the products that your jurisdiction offers. So when you describe the product, you're not only just going to call it by name, you're going to say how it is incorporated, what's required, what are the fees, the process for incorporating, so that a person who is looking at it, if you were standing in front of an audience, they would know at the end of the day whether or not they want to incorporate a company in the Bahamas or they want to incorporate it in TCI. How does that sound? I didn't hear nothing. Like, everybody's quiet.
Sounds pretty good to me.
Sounds good.
Yeah, sounds good.
So that means that that part of unit 2 will not be on your midterm exam. I pulled that to you in this presentation.
This presentation is due next Saturday?
No, it's due with the midterm.
Okay,
Yeah, it'll be due on June the 10th.
okay.
It'll be the first part of your midterm question, but I give it to you early so you can do your research and you have time to write it up. All right. So companies could be limited by shares, or it could be limited by guarantee, or it could be both. Now, companies are limited by shares. The limitation refers to the shareholders and not the company itself. The liability of the company is always unlimited. So the company is registered as limited by shares. So the liability of each of the shareholders to contribute to the capital is limited to their nominal value of the shares, either that they have agreed to take up or that they're taken up at a premium, or the shares that they still owe on. Once the member has paid the company for his shares, his liability is discharged completely. And he can't be made responsible for any deficiencies in the company. He doesn't have any liability for unissued shares. Now, if you're talking about a private company, like a small company, even though it is incorporated and it has limited liability, you'll see sometimes that it extends beyond that, because normally for small companies, especially if they're getting a facility from a financial institution, they have to give personal guarantees. So limited by guarantee, that's where there's no share capital and no liability. So normally, the members at the time are required, if necessary, to contribute towards the payment of the debt or any liability when it's the winding up. The amount guaranteed would be whatever sum is stated in the statement of guarantee on formation, and is frequently a small sum. The amount of the agreed liability may be substantial depending on the type of company that it is. Now, the guarantee is not an asset. It is really just a contingent liability. And contingent liability means that the contingent part is that it doesn't take effect until the company requires for the members to, I guess, bring to fruition what they had agreed that they would give in a winding up. So that contingent liability can be charged as a security. It can be increased and it can be reduced. So those who are members at the date of winding up, if they can't meet their obligations, then the liquidator will have access to those who are members during the prior year to the commencement of the winding up, but only in respect of debts and liabilities that incurred while they were members. If a company limited by guarantee has a share capital, its members have two liabilities. They have to pay the issue price for the shares, and they have to also honor their guarantee. And remember now, the guarantee takes effect when the company is being liquidated. So there's no benefit to the company in having a dual liability. And in practice, companies limited by guarantee with a share capital are not really formed. So the device of the guarantee company is only used where there is no share capital. That is, means no share capital is to be issued, but the members of the company want to limit their liability to contribute towards the company's debts and liabilities. So once incorporated as a guarantee company, there is no provision in company legislation for re-registration as a company limited by shares or vice versa. Since companies limited by guarantee have no share capital, they are private companies and not public companies. Under strict scrutiny, there is no restriction on such companies trading. However, these company structures primarily used for nonprofit companies and is widely used for community projects, sporting associations, education, and charitable purposes. Though the membership in companies limited by guarantee may fluctuate, such companies do enjoy limited liability and separate legal personality. And that allows the ownership of property and contractual rights and obligations without attracting personal liabilities to the members. Unlimited liability, and that's where the personal liability of members of a company of this type is the reason why not many of them actually exist. Unlimited companies must be private companies, since a public company, by its definition, is limited by shares. Unlimited companies may be formed as such either with or without a share capital. And a share capital may be used if the company is trading and making profits, since the shares are basis for the distribution of that profit. Where there is no share capital, the members contribute equally until all the debts and liabilities of the company plus the cost of winding up are paid. In any event, any members defaulting, the others are liable to make good the deficiency as much as necessary to pay the whole of the company's liabilities and the costs of liquidation. There are some features to unlimited companies. An unlimited company may reduce its capital by extinguishing liability on partly paid shares, or even repaying capital to the members by passing a special resolution to that effect. An unlimited company cannot issue redeemable shares. It may, if its articles permit, reduce its capital by buying back the shares of its members, even from out of its capital. An unlimited company enjoys privacy in regard to its financial affairs because it need not deliver copies of its annual accounts and the relevant reports to the registrar, but it must prepare audited accounts for its members. So even if the sole member or director of a private company dies, there is no board to approve the transfer of his shares under the terms of the will or on intestacy, the company is in effect paralyzed, being without a board or shareholder. The articles should be altered so as to allow, for example, a company secretary, if one has been appointed, to authorize a transfer or allow the personal representatives of the deceased member to appoint a director if the company has none. The director could then approve the transfer and the business of the company could then proceed. The article should speak to the time period to refuse a transfer, or if any power is vested in the directors, the time period to exercise after lodging the transfer, and after the court can compel the registration of the transfer. The power of refusal for the transfer of shares should actually be in the Articles of Association. Now, sometimes you can have a hybrid company, and a hybrid company is limited by shares and by guarantee. A public company is one where there is investing. And that's where the public gets to share in the profit without taking part in the management. A public company may be a company limited by shares, or it could be limited by guarantee and having a share capital. And such companies has to comply with the requirements for a public company. So here in the Bahamas, if you have a company that is moving from private to public, or it's just a company itself, it's being formed and now decided it's going public, it has to be incorporated under the Companies Act. A public company can offer securities to the public, excuse me, though it's not obliged to do so. And of course, a public company is different from a private company, as a private company is prohibited from offering shares or securities to the public. So the regulations and the supervision of a public company is done by the Securities Commission. And the role of the Securities Commission is really to make sure that the company, one, issues its shares in accordance with its prospectus, and that it is making sure that it's protecting the public interest regarding the sale and the purchase of the securities. So under the Securities Industry Act, when you're going to offer shares, that means the company is moving from private to public, or it's already public and is issuing more shares, you have to file a prospectus with the commission. Then once the company prospectus meets the standards required by the commission, the shares have to be issued to the public. And of course, you have financial reporting, your proxy reports, and they would also file a material change reporting. In the Bahamas, the stock exchange is called BISEX, and BISEX exercises its regulatory function. It looks at distribution and prospectus. It looks at the obligation of the issuer, the governance of the issuer, any misconduct by the issuer, and it also reported any security holders or public issuers. So besides having a public or a private company, beside a company being with shares or being guaranteed, or a hybrid with guarantee and shares, you have what we call a statutory company. A statutory company in the Bahamas is a segregated accounts company, and TCI is called a protected sale company. And what it's really doing is it's segregating the assets of the accounts so that if someone were to sue, it will only sue the assets in that protected sale or in that SAC. So it's really for protection as you segregate the answers. Segregate the assets. So a segregated account is an account containing assets and liabilities, and they are legally separated from the assets and liability of the company's ordinary accounts. Any company established under the segregated account legislation, they operate segregated accounts with statutory divisions between the accounts. And these statutory divisions allow the assets of one account to be protected from the liabilities of other accounts. So that what happened is that the account is now self-dependent, and that means that only the assets of a particular account may be applied to the liabilities of that account. The divisions between accounts do not create separate bodies corporate, but really what they do is they achieve within a single company what would otherwise be achieved by incorporating subsidiaries. So they're not subsidiaries. They're just a segregation of assets. So a SAC consists of a general account, or what they call a core cell, and that has the assets and liabilities, and they are statutorily separated from the assets and liabilities of the segregated account and one or more segregated accounts. So I'm not going to go through the formation of a SAC because that could be a part of your presentation. But let's look at the protected cell in TCI. It says in Section 8 of the Act, protected cell, upon application and upon payment of such fee as may be prescribed, the commission, if satisfied that the company is capable of complying with this ordinance, may register the company as a protected cell company. And the commission may impose such conditions on the granting of its consent to the registration of the company as it may consider necessary to ensure the reputation of TCI, and in particular, to vet the account owners and protected cell accounts and to ensure compliance with the ordinance. It could require the company to take certain steps to or to refrain from adopting or pursuing a particular course of action or to restrict the scope of its protected cell accounts business in a particular way. The registrar should place a copy of the certificate referred to in subsection 4 on the public file maintained by him in respect of the company. The registrar shall maintain a register of protected cell companies, and the registrar shall be available for inspection. The register shall be made available for inspection by members of the public. And of course, there is an annual fee. So a protected cell under Section 9 may create one or more cells for the purpose of segregating and protecting cellular assets in the manner provided by this ordinance. The powers conferred by subsection 1 must be exercised by the protected cell company in general, meaning unless the protected cell company's articles of association provide that they may be exercised by the directors of the protected cell company. The assets of a protected cell company are either cellular assets or non-cellular assets. The non-cellular assets of a protected cell company are the assets of the protected cell company, which are not cellular assets. The non-cellular assets of a protected cell are the assets of the protected cell company attributable to the cells of the protected cell company. That's too many cells. It's the duty of the directors of a protected cell company to keep cellular assets separate and separately identifiable from non-cellular assets. So at TCI, they use the language non-cellular assets. And under the Bahamas they call it either the general account or the core cell. But the product is the same. All you're doing is segregating assets in the event that someone wishes to sue. So another thing that you'll probably have to consider, I'll probably do some points. We'll talk about who could form a company and what are the requirements for name registration. I know in the company's ordinance and TCI, you now have to reserve a name. And those here in the Bahamas know that you can reserve a name. Sometimes you can send 2 names or 3 names to see if it's available. And then you have to talk about the documents for incorporation. So what I'll do is I'll give you all the subheadings what I want you to cover in your question for the midterm. And what may be good is that maybe if you could put the sections, I know TCI doesn't have the section in the notes, but for those here in the Bahamas, the sections are already at the end of the chapter. But what I want you to do is to really get familiar with the company and look at the process for incorporating a company and the different types of companies that are available. Any questions? So now your work has increased. Because for those who didn't present, they have a presentation. For those that didn't read Press versus Petrodel, they have to read that. And then I'm going to send the first midterm question. Is the consensus, you think it's worth 20 points or 30 points? Your presentation. $20, 25, or 30?
I think 30 would be good, but that's just me. I also have a question, Ms. Acho.
Go ahead.
For the question that you'll be sending, would it be a presentation that we have to present orally, or would you want the same in writing form?
PowerPoint, and then we can decide next week if you want to present.
Okay, no
We
problem.
could, we could probably do it, we could either do it before the midterm or after. We could decide that next week,
Okay,
because then I'll take some of the 30 points for the actual presentation. I can grade you on the material and on the presentation.
okay, Ms.
Yeah.
Acho, thank you.
So we can decide next week whether it'll be before the midterm or after. So what I'll do is I'll send the criteria of what should be in the presentation. And then we could decide that when we meet next week. All right?
Yes, ma'am.
Okay, so get to work. And also next week, I will have questions.
No problem.
Mrs. Archer, did you receive my email?
When did you send it?
Okay, this morning, for you to look out for me.
Okay, no, I don't remember. Hold on. Let me see. I can tell you right now if I see it. Where did it disappear to? Give me 1 second. Oh, okay, I see it now. Okay, all right. I'll answer you.
Thank you.
Okay, all right.
Okay.
Okay. I may also send you in addition to the midterm question, I may send you a practice question again on the Solomon Principle. And then maybe one on piercing the corporate veil, just to make sure that everybody understands the concept, okay? That sounds good. So you don't have to write it out in full. I'll send the questions. I'll separate it. One will be midterm, part midterm, and the other one will say homework. So the ones for homework will be either on the Solomon Principle itself or piercing the corporate veil or both. You don't have to write it out in full. You can do it in points and we can discuss it. But I want to make sure that you grasp what a company is. That question is always on the midterm exam and partially on the final exam. So I need you to get it in your head. Okay? So I'll work on those for you all. All right, go back, watch your coronation. And see you all next week. All right,
Thank you, Ms. Aja.
Bye,
okay,
Ms. Archer. See you next
okay.
week.
Thank you.
Also, sorry, one question.
Go ahead.
The details for the presentation, are you gonna be sending it out today?
I could,
Okay,
okay, if that's helpful, I'll do it today.
okay, well,
Okay,
thank you.
Go watch the coronation. It's on Monday.
but she wants hers today.
Get
nice.
started.
She wants to
Yeah.
get started. No, you don't have to do it today.
Well, it wouldn't be
that ca-
completed today, but just to get an idea of
Sure.
the material that I should gather to put it together.
Okay, yeah, okay. I can do that.
Okay.
Cause I said, mulling it in my head, I say, you know what? This is a good research question and they could get, instead of me just giving it to you, let you do it and you begin to own it. Which is better.
Oh. That case study that you gave us, right? When was that due?
Which one?
The one for the passing of the corporate bills for those cases.
They would do
Or else
today.
ju- Oh. Okay.
For
Yeah.
those of us that needed a little more time, so should we email you our summary or we just have
No,
to have it ready
share
for
it.
next class?
Share it in class.
Okay,
Yeah, share it in class.
okay,
And I can make a note too, when you do the two homework question, you could do it in bullet points. And then after next week class, if you want to, you could write it out in full. Because remember, I said that they will be on the final, on the midterm exam and partly on the final. So you want to be able to get good points on that. So we could do that. That's not a problem. Okay, so I'll work on this for the midterm. So I can send that out to you all tonight.
Okay,
Okay,
thank you.
all right. Have a good
Have a good
weekend.